Kenyans demanded a justice system they could trust, one that was independent, impartial, and accessible. The Constitution answered this call by mandating a people-centered judiciary, one required to deliver justice to all without delay or undue regard to technicalities. The Constitution restructured the judicial system in fundamental ways by first of all establishing the Supreme Court as the apex court, conceived as the ultimate guardian of the Constitution and charged with providing finality in constitutional disputes. Equally transformative was the reconstitution of the Judicial Service Commission, which was entrusted with the power to oversee judicial appointments and discipline, thereby insulating the judiciary from executive control. Whereas under the old order, the president had unilateral power over appointment of judges, the new JSC was deliberately diversified with representation from judges, advocates, and the public, ensuring transparency and collective accountability. Judicial reforms in the post-2010 period has been guided by the successive blueprints. The Judiciary Transformation Framework, the JTF, introduced by Chief Justice Emeritus Professor William Mutunga between 2012 and 2016, which laid a very firm foundation for ensuing rebirth of the judiciary by prioritizing institutional reform, transparency, and efficiency. This was followed by Sustaining Judiciary Transformation, SJT, under Chief Justice Emeritus David Maraga from 2017 to 2021, which consolidated the gains of the JTF and focused on access to justice, improved infrastructure, and the embrace of technology. Under the third phase of this transformative trajectory, we are now pursuing the social transformation through access to justice, STARJ, a 10-year blueprint running between 2023 to 2033. Under STARJ, we champion a very bold shift in reforms towards people-centered justice, towards a multi-door approach to the delivery of justice, towards leveraging on technology and innovation in the dispensation of justice, and ensuring that we widen the doorways of justice for the vulnerable and the marginalized who have historically been excluded from access to justice. The greatest outcome of these reforms has been strengthening of judicial independence. Today, Kenyan courts have demonstrated courage in asserting themselves as defenders of constitutionalism, earning respect across Africa and beyond. I received many delegations from other jurisdictions who are coming to understand how we have managed to remain an independent, impartial judiciary. We have some landmark court decisions upholding the Constitution. The judiciary's transformative role is most visible in our jurisprudence. Over the past 15 years, landmark decisions have defined constitutional governance, safeguarded rights, and entrenched democratic accountability. The Supreme Court's handling of the presidential election petitions exemplifies its central role in our system of governance. In 2013, 2017, and 2022, the court became the arena where the legitimacy of elections to the nation's highest office was tested. And in each case, the court anchored electoral justice in law and evidence adduced before the court rather than political expediency, thereby entrenching the judiciary as a legitimate arbiter of political disputes. In matters of devolution and bicameral relations between the National Assembly and the Senate, the Supreme Court has clarified the roles of the Senate and the National Assembly, affirming bicameralism as a cornerstone of the Constitution. In a major pronouncement on accountability in Senate versus the county governors and the 6 others, 2022, the Supreme Court affirmed that the Senate is constitutionally empowered to summon governors to appear before it or its committees to answer questions and provide information regarding county finances. The court further clarified that both the Senate and county assemblies possess oversight authority over county revenue, whether derived from the national allocations or locally generated resources. This interpretation was grounded in the Constitution's overarching purpose of entrenching good governance, accountability, transparency, and the rule of law, and the prudent financial management at both levels of government. To achieve this purpose, the court explained, county assemblies serve as the first tier of oversight at the local level, while the Senate functions as the second and final tier, ensuring a comprehensive system of checks and balances. One of the most consequential cases that has come before our courts was the Building Bridges Initiative case of 2022. And here, the Supreme Court rejected the basic structure doctrine as incompatible with the textually prescribed homegrown tier and constitutional amendment process in Chapter 16 of our Constitution. However, the Supreme Court proceeded to declare the proposed constitutional amendment initiative as being unconstitutional for having been initiated by the President, while the popular initiative route is one reserved for the public and not state agencies. In doing so, the court not only preserved the sovereignty of the people, but also defined the boundaries of permissible constitutional amendments. I expected you to clap for that. Protection of the Constitution. The judiciary has also given life to the principle of public participation, striking down legislation where citizens were inadequately consulted. This has been particularly evident as the question of public participation has become one of the most litigated constitutional concerns before our courts, with the courts in numerous decisions underscoring that constitutional requirements or public participation cannot be bypassed. In the emotive domain of land, the Supreme Court has addressed the land question in a manner that deals with the problem of land grabbing, and we have judicial pronouncements, such as in the case of Dinner Management versus the County Government of Mombasa, Torino Enterprises Limited versus the Attorney General, Akalan Semi versus Tarabana. The Supreme Court in those decisions has declared that title deeds obtained unlawfully and fraudulently would not be legitimized by the courts, thereby strengthening the constitutional promise that land must be acquired, owned, and managed in a manner that complies with the laws of the land. What that means in simple terms is that the Supreme Court recommended that we must always examine the history of any title before it can be affirmed. In socio-economic rights, the Supreme Court has affirmed the right to housing and unlawfulness of arbitrary evictions. This was done in the case of Mitubel Welfare Society versus Kenya Airport Authority, a decision of 2021, where the court held that mass evictions must be conducted humanely, recognizing the right to housing and dignity of informal settlers. Together with the case of Musembi versus Moi Educational Center, this jurisprudence has advanced social justice for vulnerable communities. The Supreme Court has also been at the forefront of expanding the frontiers of the freedom and equality. And in the celebrated Murwatetu case of 2017, the mandatory death penalty was declared unconstitutional for violating dignity and right to fair trial. In 2023, the NGOs Coordination Board versus Eric Gitari, the Supreme Court also upheld the right of association for LGBTQ persons, affirming that constitutional rights apply to every Kenyan regardless of their sexual orientation. You cannot stop people from forming an association simply because they are declared LGBTQ. Further, in the case of Monica Wangua Mwere versus the Attorney General, the Supreme Court held that the mothers of political prisoners who were violently dispersed from the Freedom Corner in Uhuru Park were entitled to compensation as their rights to freedom from inhumane treatment was violated by the state. And more recently, in Fatuma Athman Abiund Faraj versus Ruth Faith Mwahasi, the Supreme Court upheld the right of children born out of wedlock to inherit from their Muslim fathers' estates, thereby reinforcing the constitutional principle of equality and the best interest of the child. Also important for media freedom, in the case of Royal Society of Kenya versus Edward Kisiangani and the Attorney General, the High Court invalidated a government directive that sought to restrict the placement of government advertisements exclusively to the KBC. The court found that directive lacking legal authority, declared that they contravened procurement laws and undermined media pluralism. By striking down that directive, the court affirmed that the government cannot manipulate procurement policy to marginalize critical media outlets and underscored that all public procurement must comply with constitutional principles of transparency, competitiveness, and legality. That judgment thus strengthened both fair competition and press freedom as integral components of Kenya's democratic order. Do we have media people in the House? Taken together, these cases demonstrate how the judiciary has become the conscience of the Constitution, ensuring that the lofty ideas ratified in 2010 are translated into lived realities. They also confirm Kenya's growing stature as a jurisdiction whose jurisprudence is cited and respected across the continent and beyond. Beyond jurisprudence, the judiciary has transformed the manner in which justice is delivered. Before 2010, we only had footprints of the High Court in provincial headquarters and major cities. Now, court infrastructure has been expanded nationwide, with High Court stations and registries established in all the counties, ensuring that Kenyans no longer need to travel vast distances to access justice, especially in the High Court. Magistrates' courts have increased from 111 to 143 stations, with our target being the establishment of magistrates' courts in all the 290 constituencies. The Court of Appeal, which used to have a permanent bench only in Nairobi, now has permanent benches in Kisumu, Nyeri, Nakuru, and Mombasa, making appellate justice more accessible. We have institutionalized specialized courts through the establishment of the Environment and Land Courts, the only one in Africa, and the Employment and Labor Relations Courts. These two courts, known as courts of equal status to the High Court. These specialized courts have improved the handling of specialized disputes like land issues and labor matters. These courts bring expertise and faster resolution of their domains, illustrating our commitment to efficient and context-sensitive justice. The introduction of the small claims courts, now numbering 40, has enabled Kenyans to resolve disputes involving less than 1 million shillings within 60 days, while gender justice courts and children's courts have ensured survivor-centered and child-friendly adjudication of matters. I must speak about digitization, which has been the most sweeping reform. The launch of e-filing in Nairobi County in 2020 extended to all the counties in 2024, eliminating paper-based processes and creating a nationwide electronic platform for filing, tracking, and managing cases. Today, litigants can now access justice online. They pay their fees electronically and even attend hearings virtually. Real-time dashboards and online course lists have made the judiciary more transparent and accountable. Virtual hearings and AI-driven transcription have reduced delays and expanded access to justice across the country. The judiciary has embraced and is leading the continent in embracing performance management. Every day we come to work, everybody has to fill in a form digitally to say what it is that they did. This is collated weekly, monthly, and annually, which translates to the judiciary annual report, the SONJA. For us, this has been entrenched through data-driven tools such as the performance management and measurement understandings, which monitor productivity at both individual and institutional levels. Equally significant has been the embrace of multi-door approach to justice. The judiciary has actively promoted mediation. We want to build harmony and peace within families and communities. We are promoting arbitration, conciliation, and alternative justice system in recognition of the command of the provisions of Article 159 which mandates us to encourage alternative dispute resolution mechanisms. These approaches continue to play an important role in reducing case backlogs in our courts. The results of these reforms are evident. Case clearance rates have improved. The judiciary has become more open, more transparent, and more trusted as a forum for resolving disputes fairly and expeditiously. I have to talk about accountability, anti-corruption, and the emerging threats. Judicial accountability has been critical to consolidating public trust. And the Judicial Service Commission has been here, Commissioner Mwanza, and I saw a show by two other commissioners at the Nation TV radio explaining their mandates about ensuring independence of the judiciary and accountability. Independence goes hand in hand with accountability. To enhance public trust and confidence in the judiciary, in January this year, we established court integrity committees in every court station, bringing together stakeholders to identify and address corruption and unethical conduct. We were convinced that judiciary alone cannot fight corruption. We must work with others. We are therefore working closely with LSK and other state agencies like EACC to see to it that we root out corruption. The other day we launched a mobile application, a call center where citizens can call. And the message is learning is we do not take bribes, we do not ask for facilitation, and if they are brokers, because we also have many brokers who go in the name of the judge or the magistrate to collect money, we ask them to report, and those reports will be processed very efficiently to ensure that we root out corruption in the judiciary and in all the institutions. At a sectorial level, the judiciary, working with other agencies in the justice sector, through the NCAJ, spearheaded the anti-corruption strategic guiding framework for the justice sector, which we launched in March 2025. What this framework does is it provides a roadmap on coordinated action in tracking corruption across institutions in the justice sector. The Judicial Service Commission has, since the promulgation of the Constitution, diligently carried out its constitutional mandate of ensuring accountability within the judiciary by receiving and investigating complaints against judges and judicial officers. To date, the Commission has processed a total of 946 petitions against judges, reflecting the seriousness with which it treats public grievances and the commitment to upholding integrity in the administration of justice. 4 judges have been removed from office over that period. At present, at JSC, we have 95 complaints which remain pending, most of which are at various stages of inquiry, demonstrating both the efficiency and transparency of the Commission's processes. In addition, 210 judicial staff have been dismissed from the service after due process established misconduct on their part, which is a clear signal that ethical lapses within the institution will not be tolerated. Unfortunately, we don't advertise this data, these statistics, because of respect of privacy. But what these figures illustrate is the robustness of internal accountability mechanisms They also demonstrate the determination of JSC to maintain the highest standards of professionalism and public trust. However, a new and troubling threat to judicial independence has emerged in the form of cyberbullying and disinformation targeting judges and judicial officers. Certain interests exploit social media to intimidate judges and judicial officers and thereby erode public confidence in the judiciary. Such actions undermine judicial independence, which is the bedrock of constitutional democracy. While we always welcome objective criticism of judicial decisions, and indeed it is legitimate to disagree with the judicial decisions, this must be channeled through appeals and reviews. Where one has a complaint of a misconduct, it should be channeled through the Judicial Service Commission, not through digital harassment. The JSC, in the discharge of its mandate, will continue to defend decisional independence and protect judges and judicial officers from undue intimidation. The other pressing challenge is inadequate funding. We begin to now sound like a broken record. Every time we talk about inadequate funding. Despite judiciary's vast mandate, presence of courts throughout the country, and over 8,000 members of staff, the judiciary receives less than 1% of the national budget, far below the recommended 3%. This underfunding constrains infrastructure development. Our infrastructure is the most dilapidated. Our digital program, I always worry about our aging servers and the increased numbers of e-filing, and this hampers service delivery. If justice is to be treated as a public good, alongside health, security, and education, then it must be adequately resourced. In conclusion, ladies and gentlemen, as we mark 15 years of our Constitution, I want to underscore that this is a living document whose heartbeat is the people of Kenya. Sometimes in the midst of these struggles we go through to bring the life and spirit in the Constitution, I've always wondered whether Kenyans have intimately engaged with the Constitution and owned it and known that it is for them. Because sometimes you wonder, why are we being treated as if we are second-rate citizens? The country belongs to all of us, 55 million. But when you see sometimes the way we are being treated, you wonder whether this Constitution actually applies to us, whether we own it, whether we have interrogated it. So in these 15 years, what I'm trying to say is that the judiciary has transformed from opacity and subservience to one that is independent, progressive, and people-centered. Through these courageous cases, we have determined and built jurisprudence with the far-reaching reforms. Our courts have emerged as defenders of our democracy and custodians of citizens' rights. As Chief Justice, I take this opportunity to reassure Kenyans of our unwavering fidelity to the Constitution. We shall continue to administer justice without fear or favor. We shall work with the Kenyans, and our commitment remains to the dictates of the Constitution to uphold the independence, impartiality of the office of a judge, and without fear or favor to check the abuses of power, and to defend the rights of Kenyans wherever necessary. With the continued support of all the stakeholders, I'm confident that the judiciary will remain a bastion of justice and a custodian of the rule of law for generations to come. Above all, I take this opportunity to urge all Kenyans to continue defending the independence of the judiciary as the shield that protects the liberties of every Kenyan. I thank you all for listening, and I pray that God blesses all of us, blesses our country, and blesses our Constitution, and gives us the strength to continue upholding and protecting and promoting the Constitution. Thank you very much.
Better round of applause to the community.